Good morning, this is your Kelso Report for Tuesday, June 19th, and I'm your host, Clark Kelso. The Supreme Court of the United States issued 4 opinions yesterday as they near the end of their term. We begin first with an important labor law case for the pharmaceutical industry. In Christopher v. SmithKline Beecham, the Supreme Court had to interpret the scope of minimum wage and maximum hours requirements under the Federal Fair Labor Standards Act in the context of pharmaceutical sales representatives whose primary job is to obtain non-binding commitments from physicians to prescribe their employer's prescription drugs in appropriate cases. In a close 5-4 judgment, the court held that these employees satisfied the definition of outside salesman under the applicable Department of Labor regulations, and were therefore not protected by minimum wage or maximum hour rules. The regulations were ambiguous in one critical respect. They defined the term outside salesman to mean any employee whose primary duty is making sales within the meaning of the statute, and who is customarily and regularly engaged away from the employer's place or places of business. A sale under the regulations includes, quote, any sale, exchange, contract to sell, consignment for sale, shipment for sale, or other disposition, close quote. And the question for the Supreme Court was whether a non-binding commitment from a physician to prescribe a particular company's drugs constitutes a sale under this broad definition. Although this reg had been on the books for decades, and there had never previously been an issue about pharmaceutical sales representatives, the Obama administration's Department of Labor began enforcement actions in 2009. In a series of amicus briefs, the administration several times changed its interpretation of what constitutes a sale, until it ultimately took the position before the Supreme Court that a sale necessarily involved a transfer of title. Now, ordinarily, agency interpretations of their own regs are entitled to substantial deference, that whole Chevron deference thing. But rather remarkably, both the majority and the dissenting opinions agreed that the Department's recent, novel, changing, and litigation-focused definition was not entitled to any deference, and that the court was thus free to simply interpret the regulations as written. The majority read the list of things that constituted a sale and held that the pharmaceutical situation fell within the other disposition catch-all under the reg. The dissent read the same language and held that a non-binding commitment simply falls short of a sale. This is a close call on the merits, of course, and a big victory for the drug industry. But I think the most important part of the opinion from a legal perspective is the court's broad rejection of agency deference, in a context where it's pretty clear the agency's interpretations are being driven by the demands of litigation instead of being driven by the demands of policy and law. Next, we have an important Confrontation Clause decision from the Supreme Court. And although we have a result here, we don't have very much reasoning that's going to be helpful, because we have a seriously split Supreme Court. As you know, I think courts around the country have been struggling with evidentiary issues involving the admission of crime lab reports and the fairness of permitting an expert who was not involved in performing the underlying tests to testify about those test results. Everything from DNA to red light cameras. The issue in Williams v. Illinois, which was an appeal from a rape conviction, was whether the Confrontation Clause was violated when an expert forensic witness for the prosecution testified that she matched a DNA profile produced by an outside laboratory, Cellmark, based on semen from the victim's vaginal swab, to a profile the state lab produced using a sample of petitioner's blood. No one from the outside laboratory testified as to their processes and operations, and the expert had no knowledge of the outside lab's processes or operations. In a 4-1-4 split, the court held that the Confrontation Clause was not violated in this case. But because of the split in reasoning, we don't get a clean rationale from this case. The plurality opinion by Justice Alito first held that the statements referenced from the Selmark report were not introduced to prove the truth of their contents. They weren't introduced to prove their truth. They were instead introduced as essentially hypothetical premises, which then formed the basis for the expert's conclusion that there was a match. As the plurality noted, this type of expert testimony, if you bought the premise, based on hypothetical facts, has long been approved, and particularly in the context of a bench trial, such as the criminal trial in this case, the court can be assured the limits of the expert testimony will be recognized and respected. So we get a plurality opinion that sort of says this is a bench trial case. Justice Thomas provided the key fifth vote for the judgment. Thomas first rejected the plurality's conclusion that the statements were not introduced for their truth. Of course they were. But he nevertheless held that Selmark's DNA report was not testimonial for Confrontation Clause purposes, since it was not made with the, quote, formality and solemnity, close quote, required to trigger the protections of the Confrontation Clause. The contents of the report were not sworn to, and they were not embodied in a formal declaration. It was simply an ordinary business report prepared for a client, and its introduction into evidence, therefore, did not implication Confrontation Clause problems. Given the reasoning and Thomas's opinion and the conclusion in the limitations in the plurality, seems to me this issue is going to have to come back before the Supreme Court before we're going to see a clear resolution of it. Next we have a case involving government contracts and appropriations in an Indian context. The Indian Self-Determination and Education Assistance Act of the ISDA directs the Secretary of the Interior to enter into contracts with willing tribes, pursuant to which those tribes will provide services such as education and law enforcement that otherwise would have been provided by the federal government. The ISDA mandates that the Secretary shall pay the full amount of contract support costs incurred by tribes in performing their contracts, subject to appropriation. Well, Congress appropriated in a lump sum sufficient funds to pay in full any individual contractor's contract support costs. They appropriated $1.6 billion, but not enough funds to cover the aggregate amount due all of the contractors. They only appropriated about 70% of what was needed. So the question in Salazar versus Rahman Navajo chapter was whether the lump sum appropriation triggered the contractual obligation to pay full support costs to every individual contractor, even though the amount of the lump sum appropriation was insufficient to pay all of those aggregated costs. In other words, what does that language, subject to appropriation, mean? Well, in a 5-4 decision, the court held that, consistent with long-standing principles of government contract law, the government must indeed pay each tribe's contract support costs in full, because the lump sum appropriation triggered the contractual obligation to pay in every contract. The fact that the agency may run out of money in that appropriation line at some point did not relieve the agency of the obligation to pay. Next, we have an interesting jurisdiction case under the Administrative Procedure Act. In an 8-1 decision in Match E.B. Nash She Wish Band of Potawatomi Indians versus Patchak, the Supreme Court held that a neighbor to Indian property taken into trust by the United States for Indian gaming uses, who wished to challenge the United States' title to the property, but not for purposes of asserting his own title, and solely for purposes of defeating the intended use of the property, actually had prudential standing under the Administrative Procedure Act to challenge the decision of the Secretary of the Interior to take the property in trust. The case involved a technical interaction of the jurisdictional provisions of the Administrative Procedure Act, the Quiet Title Act, and an Indian lands exception to the Quiet Title Act. The district court had interpreted these statutes such that there was no jurisdiction to review the Secretary's decision. The Supreme Court's holding harmonizes the statutes so that the Secretary's decision can be reviewed under the Administrative Procedure Act, at least in cases where the plaintiff is not actually seeking to assert title in the challenged property. Next, we turn to the Ninth Circuit, in a case involving disability benefit plans. The plaintiff in Renfro versus The Funky Door suffered a shoulder injury that qualified him for benefits under a disability plan that he had with each of two separate employers, so he was covered twice. As it happened, the plan was administered by the same plan administrator, who noticed that he was covered twice. The plaintiff also was receiving a disability check monthly from the Social Security Administration, and the question arose whether each plan could deduct the amount of that check from their benefits. Both plans had identical language permitting the plan to deduct payments, quote, received, close quote, from SSI. And the Ninth Circuit held that the plain language of the plans permitted each plan to deduct the full amount of the payments from SSI, even though this meant that the total benefits received from the plans, when taken together, would be reduced by 2 times the SSI benefits. Other provisions in the plans actually made allowances for the possibility that an employee would be covered by multiple plans. But the particular provision dealing with SSI benefits was not drafted to take account of that possibility. The court's opinion recognized that the result might seem harsh, but it was in fact dictated by the terms of the plan itself. Now we turn to 2 opinions from the California Supreme Court. For 8 months during 2010, a now superseded version of Section 4192 of the Penal Code increased the rate at which prisoners could earn conduct credits for time spent in local jails. After its enactment, the issue arose whether its provisions applied retroactively to benefit prisoners who served time in local custody before the new version became operative. The Supreme Court unanimously held that the increased rate for conduct credits applied prospectively only, meaning that qualified prisoners in local custody first became eligible to earn credit for good behavior at the increased rate, beginning on the statute's operative date. The court rejected arguments that retroactivity was required under the equal protection clauses of the federal and state constitutions. In essence, in both its statutory interpretation and constitutional holdings, the court concluded that the change in conduct credits was not a matter of changing punishment for crime, and was instead related to sound correctional administration, a topic about which the legislature can act prospectively only. Next, in Gomez v. Superior Court, the Supreme Court held that a court commissioner has the authority to summarily deny a petition for writ of mandamus or habeas corpus under Code of Civil Procedure Section 259, at least when the petition seeks to enforce a prisoner's rights while in confinement, but does not seek to collaterally attack the criminal conviction that provides the basis for the confinement. So limited, such a denial constitutes a subordinate judicial duty within the meaning of Article 6, Section 22 of the California Constitution. And that's it for today's Kelso Report. Have a great day in the law.